Good afternoon. I'm Rosslyn Butler, your host for Real Estate Network. Today, we're interested in providing you with some very important information for landlords, homeowners, renters. On a weekly basis, we want to update you on the ever-changing facts that are going on. Governor Newsom signed into law through AB 3088, which extends protections against evictions to renters. One of the problems with all of this is that our governor is now under scrutiny to be recalled because a lot of people feel that he did not have their interests at heart when he put forth this legislation. But due to the pandemic and the moratorium that was nationwide due to COVID-19, he saw fit to give relief to the workers of America that had to pay this rent and they were not allowed to go to work. So in early April 2020, the Judicial Council enacted an emergency eviction. Note the term, an emergency eviction, for temporary emergency rule number 1 to help stem an expected deluge of election proceedings due to non-payment of rent caused by the financial effects of COVID-19. On August 13th, the Judicial Council voted to end its statewide moratorium on evictions effective September 1st. So as of 2020, September of 2020, that was the first time that the eviction ban was supposed to end. However, it did continue. As you know, we're still under the laws of the moratorium and the eviction today. Although numerous bills were considered, AB 3088 emerged as the primary legislative response after negotiations between the governor, the legislators, the apartment owners, and the tenant advocates. So all of these entities came together understanding what this bill would do and how it would help the average person. AB 3088 took effect immediately upon the governor's signature on August 31st, 2020. The bill is not considered to be long-term fix to the COVID-19 crisis. However, it does provide the legislature with 5 months to come up with a longer-term solution. So they were supposed to come up with a longer-term solution. Nothing ever happened, so we're still into this bill currently. AB 3088 extends eviction protections to residential tenants who declare to their landlords via a written notice under penalty of perjury that they have a financial hardship related to COVID-19. Hardships can range from loss of income, increased work expenses, or increased health care, child care, family care, and expenses caused by COVID-19. The bill protects a wide range of tenants or apartments, single-family homes, duplexes, mobile homes, and accessory dwelling units, which means these new ADUs that they attach to the rear of the properties, or if someone made a rental out of their garage, that would be what that would be covering. So you are covered if you live or exist, that's your domicile inside of any of these areas on a property. Tenants who timely send their landlord a hardship declaration cannot be evicted for failing to pay rent that was due between, write these dates down, March and August of 2020. So the first big area that you did not have to pay rent in was from March to August of 2020. In addition, tenants who send the hardship declaration cannot be evicted for failure to pay due between September 2020 and January 2021. That's the second area where you did not have to pay due to COVID issues. And if you declared it with the declaration, be clear. provided that the tenants pay at least 25% of the rent due during the period. Now, each tenant, let's be clear, when there is another form the landlord should have given you, one was the new law, two was this declaration, and three was a form that indicated how much you paid. And the other side of the form shows what you still owed. This is to be submitted to the landlord every month so that you are covered under these guidelines. In addition, tenants who send the hardship declaration cannot be evicted from September 2020 and January 2021. Higher income tenants, which means people that make over 80,000 a year or 100,000 a year and above, or 130% of the area median income. There is a chart. You have to go into one of the local websites, find out what the median local income is for your area if you're above 100,000 to see if you qualify. So this is not automatic qualification. It is income based. Let's be clear about this so that you don't, get there and think you qualify just because you had COVID. You do have to meet some income requirements. It's good to note that unpaid rent is not forgiven. I repeat, your unpaid rent is not forgiven by the legislation and remains owed to the landlord. So most people are thinking that this moratorium and this eviction process and the tenants' rights protection, you don't ever have to pay this rent again. That is not the case. And we will go forward with explaining this very clearly, what your responsibilities are. So for those two periods that I just outlined, yes, you did have to pay 25% of the rent, or you could have been given an eviction notification. In some states, they are activating this. Here in California, it is not. The judge will tell the landlord at this point, until this ban has been lifted, that they cannot go ahead and file any evictions. To this date, the date now is October 1st. You must have paid at least 25% of the rent to the landlord by October 1st. And baby, I heard the other day, the full amount of the rent for October, because it's out of the band at that point. So you're really paying that 25% for the months leading up to it. So from say January 2021 to October will be the next period that you need to be putting your money together to pay that 25%. If landlords want to pursue evictions against residential tenants who are behind in their rents, landlords will need to send notices containing a statutory explanation of tenants' rights under the new law. You need to get that. Landlords also must provide tenants with hardship declarations, and that they are printed in the same language used in the lease. So if you're Hispanic or if you're some other nationality, they should have it written in your language so that you understand clearly. Tenants have 15 days to complete and send the declaration to their landlords. On October 5th, 2020, October 1st, 2021, courts can resume summons for unlawful detainer actions and can continue processing those actions. The new law allows landlords to pursue unlawful detainer actions in a variety of circumstances, including non-residential tenants, evictions for lease defaults, other than non-payment of rent. You are aware that you have heard that a landlord could evict you for other things that you have broken in the lease, such as where you park, being a nuisance in the building, drugs and alcohol disturbances, moving extra people into the unit, getting an animal. There's many other things that cause you to breach or break a lease that they could still evict you for. but not the non-payment of rent until this moratorium ends. So you do have the protection under the law for that. The new law allows landlords to pursue unlawful detainer. Evictions for lease defaults other than non-payment of rent, evictions for missed rent payments prior to March 2020 is another reason that they could ask you, well, could file the paperwork on you. If you were already being evicted or were 3 days, had got a 3-day notice, let's say in January or in December, they can evict you. Evictions for non-payment of rent unrelated to COVID-19, they could also pursue that as well. Landlords are prohibited from evicting a tenant for a reason other than non-payment of rent in retaliation for unpaid COVID-19 rental debt. So let's say they're just mad because they haven't been getting the rent. So they're trying to make up something that you did back in 2019 or 2018. That's not going to fly. There are protections that you have for that period, and they cannot move it forward to put you out of the property. Landlords are prohibited from evicting a tenant for a reason other than the non-payment of rent in retaliation for having unpaid COVID-19 rental debt. AB 3088 also penalizes landlords up to $2,500 for resorting to self-help to evict a tenant, such as locking the tenant out, throwing personal property out onto the curb, or shutting off utilities rather than going through the required court process. Be clear, if your landlord has entered your apartment, has threatened you, harassed you on a daily or regular basis with over excessive phone calls, come by, opened your door, come inside, threw some of your property out, threatened to have people manhandle you out of the property, any of that is against the law and they can be brought up under charges. So none of these can help. So you cannot be subjected to lockouts. We do have programs that provide a call to the sheriff that can help you if you're being evicted by the sheriff. If you have signed this declaration, there's a lot of help out there to get you to stay in the property even though you have not paid your rent, particularly if they've broken the law. Any of these items, locking you out, throwing personal property out on the curb, shutting off your utilities, I've heard that a lot, and rather than going through the required court process, they are now in violation of the court and you can file action against them. AB 3088 does not prevent existing eviction moratoriums by local governments, which remain in place until they expire. So nothing has expired as of yet. It is scheduled to expire October 1st, 2021. However, new local eviction moratoriums passed after August 19, 2020 cannot take effect until later in the year. All of this has a lot to do with the eviction process, and let's go through this real quickly.